So if you somehow missed it, HYBE lost in court against Min Hee-jin over the stock put option lawsuit and was ordered to pay 25.5 billion won, which is roughly $19 million USD, to Min Hee-jin. Well, it's no surprise what was going to happen next because they told us right after that HYBE was going to appeal. And indeed, that is exactly what happened. And I feel like Twitter's known for a few hours, but I always at least try to wait for a couple official news reports before reporting on this. But yeah, HYBE had already said they were going to appeal, and indeed, they have officially put in the appeal, which means that this case is going to another trial. And this legal fight started all the way back in April 2024, when tensions first exploded between HYBE and Min Hee-jin over alleged management control issues and claims involving new genes. But yeah, again, the court gave Min Hee-jin a big win, so HYBE is kind of on the back foot now in this fight. And while HYBE is, of course, upset about this, I wanted to talk about another organization who I've talked about in the past, and that is the Korea Music Content Association, because they also aren't happy about this and released a statement just in the last 24 hours saying, quote, "After reviewing the first trial ruling between HYBE and former CEO Min Hee-jin, we as an organization working for the development and enhancement of the K-pop industry express deep concern. The K-entertainment industry has grown based on mutual trust between capital investors and those who contribute their expertise and capabilities. Talent cannot flourish without investment, and investment has no meaning without capable contributors. In this ruling, we are concerned that the court standards for determining a breakdown of trust differ significantly from what the industry considers appropriate. We believe the ruling viewed acts that could constitute a breakdown of trust, a fundamental and essential element, too narrowly. At the same time, by setting an excessively high threshold for such a determination, actions that may be recognized within the industry as tampering, the act of inducing an artist to leave during the term of an exclusive contract, could be interpreted as legitimate management activity, or as conduct that does not entail substantial responsibility. In a K-pop industry that operates on trust, if the head of an affiliate or key executives were to use improper methods to extract a successful artist's intellectual property and seek independence through a new company, this would inevitably deal a serious blow to overall governance stability and investment predictability across the industry. Tampering is not merely a contractual dispute, it is a fatal act that undermines the very foundation of trust in the industry and fundamentally damages the long-term pre-investment structure. We strongly urge that in the appellate trial and subsequent legal proceedings, careful consideration be given to the broader impact this case may have, not only on the K-pop industry, but on all IP-based industries. Which just say, yeah, they mad. They weren't ready for this, and they're mad.